Hi there, and welcome to part 2 of this contract law series. Today's focus is the doctrine of acceptance. By the end of this video, you'll be able to recognise exactly at which point during the formation of a contract acceptance has actually occurred, and quickly spot the pitfalls and exceptions. Obviously, being part 2 of the series, if you haven't watched part 1 on offers yet, which is obviously the best starting point in English contract law, or if you want a refresher, stop right here, click on the card in the corner of the screen now, which will give you a link to the video on offers. Check that out first, and at the end of that video there'll be a link back to this one so you can carry on with acceptance. For everyone else, let's pick up where we left off. We have an offer on the table, now we need acceptance to lock that contract down. So what is acceptance? Acceptance is a final and unqualified expression of assent to the terms of an offer, and this is where examiners love to trip you up with tricky timelines. So let's break down 3 major rules of acceptance, and then consider revocation and modern forms of communication of acceptance, such as WhatsApp messages and emails. So let's begin with the mirror image rule. Your acceptance must match the offer perfectly. It has to be an exact mirror image. If you change even one minor term, you haven't actually accepted the offer, you've killed the initial offer and created a counter offer instead. And obviously when a counter offer is created, the offeror is under no obligation to stand by the original offer created. Let's start with an old case called Hyde and Wrench from 1840. In this case, Wrench offered to sell his farm to Hyde for £1,000. Hyde said, "I'll give you £950. Wrench refused. Hyde then said, "Okay, fine, I'll pay you the £4,000. Wrench refused again to sell it to him, and Hyde sued him. In the verdict, the court upheld Wrench's defence. Why, you ask? Because the moment that Hyde offered him £950, instead of accepting the £1,000 initially offered, he had killed that original offer, which again cannot be revived unless the offeror chooses to do so. In this instance, Wrench changed his mind. Now, there is a nuance to all this sort of thing. What if you just ask the question instead? What if Wrench says £1,000 for a farm, and then Hyde says, "Would you accept the payment over 2 instalments? Is that a counter offer?" No, in this case it's not. As a general rule, that would be deemed as a mere request for further information. Henceforth, the original offer stays open, of £1,000 in this case. If you consider the case of Stevenson, Jackson Co. against McLean from 1880, again another old one, that will support the request for further information and regard it as being a mere inquiry. So whatever you do, don't mistake it for a counter offer, because it isn't. So requesting more information in relation to payment terms or instalment plans is not a counter offer. Now in the next rule, acceptance must be communicated. It cannot be silent. And mental acceptance isn't enough. You can't just decide in your head that you're going to agree. So in practice, you cannot force a contract on somebody by saying, "If I don't hear from you, I assume we've got a deal." So the law does protect people from having to actively reject unsolicited offers. The leading case for this is Felthouse and Bindley from 1862. In this instance, an uncle offered to buy a horse from his nephew. The uncle wrote, "If I hear no more about it, I consider the horse mine at £30 and 15 shillings. The nephew was quite happy to sell it to his uncle, but he didn't reply. He simply told the auctioneer to keep the horse out of the upcoming auction. For one reason or another, the auctioneer didn't do that and sold the horse at auction anyway. The uncle attempted to sue the auctioneer, claiming the horse should have been his, but the court held that there was no contract between the uncle and the nephew, because even though the nephew had intended to sell and requested that the auctioneer withdraw the horse from the auction, he hadn't actually communicated his acceptance to his uncle. So, a great example of how silence is not classed as acceptance. One could argue, of course, that acceptance was attempted to be made by actions, as in requesting that the auctioneer take the horse out of the auction, but of course simply by taking the horse out of the auction isn't confirming to the auctioneer or the uncle that the uncle has the right to purchase the horse. Next we'll have a look at one bizarre example to the communication rule in relation to acceptance, the Postal Rule. I know, this rule is a fossil from the 1800s, but it's still valid today, and believe it or not, people still use the post. In this instance, acceptance is actually classed as being given as soon as the letter of acceptance is posted in the postbox or collected by the courier, not when it arrives, but when it is dispatched. The basis for this principle is Adams and Lindsell from 1818, very old case. In this instance, the defendants offered to sell wool to the claimants. The defendants completely messed up the address, so the offer letter arrived late. The claimants immediately posted their acceptance, but because the defendants hadn't heard back in the expected time frame, they assumed the claimants weren't interested in the wool and sold it to somebody else. In this case, the court ruled the contract was indeed formed, and the very second the claimants dropped their letter of acceptance in the postbox, even though the defendants had no idea it was coming. But it gets crazier than that. In the case of household fire insurance and grant from 1879, it was decided that the Postal Rule even applies if the letter is destroyed in the mail and never arrives. As long as you can prove you posted the letter correctly, confirming your acceptance, the contract is legally binding whether the letter actually arrives or not. So always good advice to get proof of posting if you're accepting an offer. But it does of course place an enormous risk on the person that's actually making the offer. And you must remember, this only applies to acceptances and generally does not apply to instantaneous communication such as emails, texts or WhatsApps, which are actually nowadays deemed as accepted on receipt of the message as opposed to on sending of it. The foundation for this principle in relation to electronic messages was laid out by Lord Denning in Entores Limited against Miles Far East Corp in 1955, which is still a leading authority on instant communications, like telex at the time, or fax, email, instant messaging, text messages and WhatsApps. The court established that the Postal Rule does not apply in these circumstances. Acceptance actually occurs when and where the message is actually received by the recipient system, not when it's sent. Lord Denning's Entores Instantaneous Communications Principle was later refined by the House of Lords in Brinkybond Limited against Stahl in 1983. A bit more recent, where it was decided the receipt of the instantaneous communication should be expected within normal office hours or at a time when it would be reasonably expected for the recipient to be able to receive it. So if you sent an email and it arrived at 1 o'clock in the morning, in the middle of the night, it wouldn't necessarily be deemed as being received until the start of business or whenever the person starts work the next day. If they start at 8 a.m, it would be deemed as being received at 8 a.m. However, if that person works nights and it was delivered at 1 o'clock in the morning, obviously it would be assumed that it was delivered at 1 o'clock in the morning. So although the principle is fairly objective, you would have to agree that actual receipt of acceptance will be subjective on the recipient's actual usual hours of work. For a very up-to-date example, there's Jaevee Homes Limited against Fincham from 2025, which has frequently been cited recently for the use of WhatsApp in relation to acceptance. Fincham, the contractor, asked Jaevee Homes, the developer, if he had the job via WhatsApp message. The CEO of Jaevee Limited replied a simple yes, and in this case the court held that the simple one-word answer of yes was sufficient to be acceptance of the offer due to the prior discussions on price and scope of the job. So even if a different form of contract with different terms was sent afterwards, the original terms agreed in the WhatsApp messages, confirmed with the yes, was upheld in court. Obviously this area of law is still evolving, and the court set additional expectations regarding WhatsApp communications concerning high-value property by adding the condition that the acceptance must be confirmed by also typing your name at the bottom of the message as a form of signature to show an official authentication of your intention to accept. This is confirmed in Reid-Roberts against Mei-Lin 2026. Regarding revocation of your offer, there's Byrne and Van Tienhoven from 1880, which dictates strict rules of revocation. An offeror can withdraw their offer at any time before acceptance, but crucially, that withdrawal must be communicated to the offeree. And unlike the Postal Rule for acceptance, any form of communication revoking an offer is only effective upon receipt by the offeree. So to sum up today's discussion, acceptance always needs the mirror image rule, where the acceptance must perfectly reflect the offer, and for that you've got the Hyde and Wrench case. Obviously if there's a mere request for more information, we've got the Stevenson and McLean case, and in relation to acceptance being conveyed correctly and not relying on silence, you've got Felthouse and Bindley. Then of course you've got the Postal Rule from Adams and Lindsell, or for acceptance by digital communications, you've got the Entores case. So contract law is fundamentally about identifying the exact moment two parties reach a consensus, a meeting of the minds. However, as some of these rules demonstrate, on occasion the courts are forced to shoehorn modern evolving methods into 19th century legal doctrines. Now to follow on the next video, we're going to look at consideration, the requirement that something of legal value must be exchanged to make any agreement legally binding and enforceable. And we're also going to consider the doctrine of promissory estoppel. Don't forget to hit like and subscribe for more topic breakdowns. Share these videos with any colleagues or friends that you think might benefit from them. Drop any questions or queries in the comments box below. I do try and reply to all comments, and I'll see you in the next one.